court seemed to be concerned that the records that we were asking for had not been given to the district court judge so that she could review them in chambers, because that's usually what happens, and then the district court judge looks at the documents in chambers and decides whether there are any privacy interests, and the court does the constitutional balancing test. The court was concerned that we hadn't done that in this case, and the commissioner's office was kind of blaming me, and I had an easy question to explain why that didn't happen, but I neglected to say that I think the reason why usually it's the custodian. I don't have the documents, so it has to be the custodian of the documents, in this case the commissioner's office, that has to give the records to the judge. And usually they file a motion. The person with the records files a motion and asks the judge to look at them in camera. And that didn't happen in this case, and I think it didn't happen because the commissioner took the position in this case that the federal act, FERPA, would not permit the commissioner to even acknowledge that he had records belonging to Jordan Johnson. So it would have been very difficult for the commissioner to maintain that argument and at the same time give a bunch of documents to the box of documents to the judge to review in camera. And I meant to make that point because the court was obviously wondering why that in-camera inspection hadn't been done, and I would have made that argument if I had given my oral argument, but I ended up answering questions the whole time.
Sure.
Anyway.
Now, let me ask you this. Do you think, because in listening to both sides, it seemed like the court asked very probing, difficult questions, and difficult to answer to both sides. So did you feel like you got a fair shake before the state Supreme Court?
Oh, absolutely, absolutely. It wasn't. I don't mind probing questions because it demonstrates the fact that the court has read and is familiar with the briefing in the case. So I invite that kind of questioning because it helps me explain something that we may not have explained very well in the briefing. And sometimes when you have a real technical kind of legal case, it's easy to not be aware that the judge has some problem with this aspect. And when they ask the question, you get a chance to address it. I think it's great. I welcome it.
Okay, one more quick thing, and I'll let you go. What do you think of the commissioner's office argument about losing federal funds should these records be made public?
It's hogwash. No state has ever lost federal funds as a result of disclosure of records, number one. And number two, FERPA only causes jeopardy to funding of an educational institution if they engage in a pattern and practice of systematically disclosing student records. In Montana, because the question of whether records would be disclosed is done on a case-by-case basis, whenever a court requires disclosure, it can't be a pattern and practice, and there's a provision in FERPA that permits a court to make that kind of an order. So I wasn't buying that argument, and there's no way this university is going to lose any funding.